Morning and welcome to Citizenry Center. Welcome back for those of you who might have been on our Facebook live stream a few moments ago. We are back after some minor technical difficulties. A quick introduction to CAC. We are a nonprofit, nonpartisan community legal organization. We're dedicated to building and promoting transparency, accountability, and access in government in Illinois, especially at the local level. On that front, we are here today to talk about FOIA, the Freedom of Information Act. We're going to run through the nuts and bolts of FOIA, some of the common pitfalls that people run into, and where we see a lot of issues with whether it's pushback from government bodies or trouble that people run into in submitting requests. For those in the room, how many people have submitted a FOIA request before? Excellent, excellent. It's not that hard. We're going to go through, for the folks who haven't done it, just the process, and then we are going to talk about some of the different things that can happen throughout your request. Please feel free to ask questions throughout. Those on Facebook Live, we don't currently have a way to ask questions, but feel free to call our office and ask questions. All right, just moving to the next slide for the folks in the room. We have a quote. Miriam, you want to read the quote since you're closest?
It says, if the broad light of day could be let in upon men's actions, it would purify them as the sun disinfects. Justice Louis Brandeis.
Pretty good quote. What's everyone think of that quote? What is that? How does that relate to FOIA, do you think? Anyone? Yeah.
I think it means have the power to hold those in power accountable.
Yeah, exactly. Shining light on government actions, holding them accountable, letting people see what's going on. Any other thoughts on it? Yeah, Christian.
I think what happens when behind closed doors and bring it out in the open.
Mm-hmm.
So there's no secrecy.
Right, no secrecy. Excellent.
Also, people are, if their actions are public, they're less likely to do something that they'd be ashamed or embarrassed or illegal.
Very good point. And I think in our work we definitely see that. All right. So I think that's a good setup as we get into just an overview of our quick agenda today. We're going to have a history and background of FOIA. We're going to talk about what is a public body under FOIA and what is a public record. Those are two key components. We're going to talk about exceptions. There are both statutory exemptions and then some trouble you can run into depending on the type of request you submit and how broad it is. And then we're going to talk, actually I moved this around, we're going to talk about how to submit a successful FOIA request right before the exemptions. So, getting right into it, a little bit of history. The modern FOIA statute at the federal level came about in 1966. Every state in the country, as well as the District of Columbia, has its own Freedom of Information Act law. They're all a bit different. Some of them are pretty similar. Some of them are pretty broad. Others are pretty narrow. A good example of a narrow one in the state of Virginia, only Virginia citizens are allowed to use their Freedom of Information Act. So if I want to get information from there, they don't have to give it to me under their FOIA law. In Illinois, we have a fairly broad FOIA. You'll see that we do have some exceptions to it. Some of the states' laws actually predate the federal statute in 1966, but in Illinois, our modern law came about in 1984, and we see amendments to it fairly frequently. We're always weighing in on those as the General Assembly tries to change the law. So we're going to focus first on the preamble in FOIA. It's this big section at the beginning of the law, a lot of lofty language about some of the goals and the enactment of the law. And it really, not only does it tell us what the General Assembly was thinking as they enacted FOIA, but it also relates to how the law is interpreted. So does anyone want to read this first section?
I will.
Okay, Sue.
Go on. Pursuant to the fundamental philosophy of the American constitutional form of government, it is declared to be the public policy of the state of Illinois that all persons are entitled to full and complete information regarding the affairs of government and the official acts and policies of those who represent them as public officials and public employees consistent with the terms of this act.
Does anything from that jump out at people? Any phrases in there that you think might weigh on interpretation or what the General Assembly was thinking on this law?
Full and complete information.
Full and complete
Affairs
information.
of
Yeah.
government, right?
Broad, right?
Yeah.
It's really saying they want all information about government out there.
And also, all persons are entitled. Everyone's treated the same.
All persons. That's a big one. I mean, we just talked about Virginia, where it's not all persons. It's Virginia citizens. This is a pretty broad preamble, pretty broad statement that the General Assembly intends for not only Illinois residents, but everyone to get full access to the information provided by this act. Next slide. I'll read this one. Such access is necessary to enable the people to fulfill their duties of discussing public issues fully and freely, making informed political judgments, and monitoring government to ensure that it is being conducted in the public interest. I think the CAC mission really approves of that one, as watchdogs. Anything jump out from that paragraph?
The expectation is that the public will be civically engaged.
Mm-hmm.
Right.
Yeah, there's a responsibility here, right? They're giving you this information, and it's with the expectation that the public is going to actually take take this information and care about their affairs and influence the people making decisions. All right. Next, the General Assembly hereby declares that it is the public policy of the state of Illinois that access by all persons to public records promotes the transparency and accountability of public bodies at all levels of government. It is a fundamental obligation of government to operate openly and provide public records as expediently and efficiently as possible in compliance with this act. Similar to that first paragraph, right? But this really is putting that obligation on sort of those individual bodies. It's talking about how it is their obligation to be transparent and accountable to the people. Again, broad language. This is going to come into play as you look at the interpretation of the act, as you see local public bodies maybe try to push back against requests. All right. The act is not intended to create an obligation on the part of any public body to maintain or prepare any public record which was not maintained or prepared by such public body at the time when this act becomes effective, except as otherwise required by applicable local, state, or federal law. So what's that mean?
Retroactive.
Not retroactive.
Something doesn't have to be prepared. In order
Doesn't have to be prepared. They're not data record. It's got to be something existing. That's something to remember throughout all of this. And we'll talk about it when we talk about submitting a FOIA request. You got to think about what documents do they have to have. What documents do they have? The Local Records Act in Illinois, and we'll talk about that a little bit, governs what they have to keep, and then other documents they might have pursuant to the functions of government. All right, restraints on access to information to the extent permitted by this act are limited exceptions to the principle that the people of the state have a right to full disclosure of information relating to the decisions, policies, procedures, rules, standards, and other aspects of government activity that affect the conduct of government and the lives of any or all of the people. The provisions of this act shall be construed in accordance with this principle. Thoughts on that section?
Pretty broad.
It's broad, right? And it's broad, and it's kind of it's a bit of a flowery way to just say that the exceptions are limited, and once again repeat and emphasize the fact that they want all information, at least to the extent possible under the act, available to the people. They've repeated themselves a lot of times here in different words. Okay, that is the end of the preamble. I want to point out one other thing that I don't have on a slide. They talk about under here that there's an understanding that it does create an obligation, possibly a financial obligation, for units of local government. We see some pushback there occasionally. There are bills all the time trying to limit what they call unfunded mandates. The General Assembly makes very clear that they believe open government is worth the cost, that they understand that there is not a financial obligation to public bodies under this, but that it's part and parcel of running a government in a democratic government. With that said, let's jump into the nuts and bolts. So what does FOIA do? Anyone want to read that first bullet point? Mike?
Each public body shall make available to any person for inspection or copying all public records, except except as otherwise provided in section 7 and 8.5 of this act.
All right, so that is really our enacting clause. All that preamble language boils down to this. Each public body shall make available these records. So all persons, again, unless it is exempted under those two sections. And we'll get into those exemptions a little later. They're pretty specific, and that's an important thing to remember even before we get there. Additionally, the Act says all records in the custody or possession of a public body are presumed to be open to inspection or copying. Any public body that asserts that a record is exempt from disclosure has the burden of proving by clear and convincing evidence that it is exempt. Very narrow on those exemptions. Any other thoughts with that before we move on? Questions on it?
What I know is that it's not only that you can get copies of records, but you can inspect the original
Yes,
records.
and that's a good thing to point out, and especially as we get into how to submit a request. With copies, you can always be charged as well. With inspection, they can't charge you, even if they have to make copies to redact information or anything. They can't charge you for that, and you are allowed to copy those records yourself. So you can bring in. They have a neat little app called I can't remember what it is. A scanning app on your phone anyway, and you can go in and scan those documents. You just have to make an appointment. Okay?
Does that imply electronic documents also?
Yes. Yes.
So you would have to see the original.
Yes, and you are allowed to inspect the original. They might have to create a new document if they're redacting information. So that's the point. Now I have highlighted two words up on the screen in that first little section. Each public body I have highlighted shall make available to any person for inspection or copying all public records, again highlighted, except as otherwise provided in Section 7 and 8.5 of this Act. So those two phrases, we need to know the definitions of them. We need to know what is a public body and what is a public record. Well, let's jump right into it. So what is a public body? This is defined under the Act, but it's not necessarily clear when you get into the weeds on it. It says public body means all legislative, executive, administrative, or advisory bodies of the state, state universities and colleges, counties, townships, cities, villages, incorporated towns, school districts, and all other municipal corporations, boards, bureaus, committees, or commissions of this state, any subsidiary bodies of any of the foregoing, including but not limited to committees and subcommittees thereof. Pretty broad, right? This is also pretty similar to the Open Meetings Act. What we find, though, is that the bounds of the Open Meetings Act, where they're looking for deliberation in public business, and they're looking for the authority of that board to make decisions and quorum and all those things, that doesn't exist here. We're actually somewhat broader in terms of what's going to fall under this. For those of you who were at the open meetings discussion, for instance, there was an ad hoc committee in Naperville that was not subject to the Open Meetings Act because it didn't really have any formal position within the government. It didn't have final decision-making authority. However, had they created documents, those would be subject to the Freedom of Information Act. So a little bit of a different standard under that. Any other thoughts just with this basic language before we move on? Any questions about it? And we'll get into some of the gray area. How about legislators? So there's this case, Quinn v. Stone, from 1991. Jean Quinn was executive director of an organization called Chicago Metro Ethics Coalition, and she submitted a FOIA request to a Chicago alderman named Bernard Stone. This request had to do with his finances, his spending of public funds, including related to his travel as an alderman. He ignored the request. Did the court order Stone to turn over the information? What do you think? You hope so? What do you? Well, so what's the question here?
Is the General Assembly subject to FOIA?
Well, this isn't general. This is alderman. This is an alderman.
Yeah.
Chicago alderman.
Legislators.
Yeah. So our legislators, legislators, they consider Chicago aldermen of a city to be legislators. I know it's a little bit tough for us to think about that at the local government level, but that's what they. So we're talking about individual members. So really, what's the question here?
Is it a public?
Is he
using public funds?
Well, not public funds, but
Is Stone a public body?
is he a public body? Exactly. Because it's public bodies that are subject to the Act. So is he individually a public body? And does he have to comply with this request? Christian?
Well, when you put it that way, I'd like,
Yeah, I guess I'm leading a little
no,
bit.
yeah, but there'd be a paper trail, right, coming from the public body that gave him those.
Ah, there would be, wouldn't there? Well, no, he does not have to turn them over himself. The quote, the sort of the big quote from there: an exhaustive review of both state and federal law defining public body reveals no case which would include an individual alderman in that definition. However, they note very specifically that they are not ruling on whether she is entitled to the information. She sent it to the wrong place. Had she sent it to the public body's FOIA officer or the head of the public body, they would have had to have responded if those records were in possession or created by or any of those other, all those different definitions of a public body. If they had control over that document, they would have had to have complied.
So had you sent it to the city council instead of him?
Correct.
Okay.
So, Christian.
I think I have a good sense of where you're trying to get us. That's why I could sense that was going to be a no.
Oh, well, yeah, I mean, I try not to lead too much. I want to have a little bit of debate, but there's only so much I can do in a case like that, I guess. So, well, maybe the next one will be more of a curveball. So this is Champaign v. Madigan. So a reporter sent a request to the city of Champaign. I believe the reporter actually saw some aldermen kind of texting and writing emails during a city council meeting. And the reporter asked categorically for all copies of all electronic communications sent and received during city council meetings from members of the Champaign City Council, as well as the mayor of the city of Champaign. The city denied the request. So there are two questions here. Are these communications subject to FOIA after Quinn? What do you think? Are they?
I want to say yes.
No, they're not a public record.
Not a public record? We'll get in. There is a public record question here, and we'll get into that. But how about public body? You know, you have a right to documents of a public body. Are the individual emails of aldermen documents of a public body?
Unless he's sending unless the alderman is sending it to the city of Champaign office.
City of Champaign.
Yeah.
I think you're getting at
topic.
Right.
about the topic definitely matters. Christian.
I was thinking like whether or not I think it's just too broad. Like, what if someone sent a personal email through a personal email account during a
Yeah. Well, and that's really getting towards the question of what is a public record, and there is that issue here too. But are these communications? So the Quinn question was: are these individual aldermen a public body? Is there something different here? I guess is what I'm asking. Miriam?
They're sending them during
a meeting.
of the public body.
Yeah, they're meeting as a public body, and they're sending these during the meeting. So we'd have a different question if they asked for them outside of that. Does it matter that the communications are on personal devices or accounts rather than city devices and accounts? No?
Wasn't there a recent ruling?
Yeah, there have been several. Mayor Emanuel was subject to one of those. You know, it's funny because as advocates, I think it sounds obvious that they can't get around this just because it's on a personal device. And we've seen that play out at the federal level. One of the early cases on this, I thought, had some really great language. It was a government scientist who had information on a personal device, and they didn't want to give it up. And the judge likened it to that same scientist taking a box of documents that we know would be subject to FOIA and just putting them at his sister's house. I mean, right? Wouldn't really make sense if that got them around it. So, you know, they could, the public body would have to try and get those back. They would have to tell their employee to bring those documents back. And similarly, they have to tell that employee to turn over the emails on a personal device if they are related to the public body.
Doesn't that get into a whole enforceability issue?
It does get into an enforceability issue. I would say that the biggest thing here is it is a legal action, and if individual legislators or other public officials are lying about it, there are pretty big consequences. They can get into some big trouble if they lie about it, don't turn things over that they're supposed to. There are some substantial individual penalties under FOIA. Never really enforced, but presumably they could be, especially if you had a really bad actor.
Does it apply if other emails and things are mentioned in a public meeting but aren't sent at that time?
Well, so that's an interesting question, and that sort of gets to one of the exemptions we'll talk about later in terms of preliminary documents and everything. So we'll get into that a little bit when we're talking about exemptions. It's a good question. Okay. So you can see there I just said, yes, individual legislators are still subject to FOIA as individuals, but these communications were sent, are still not subject to FOIA as individuals, but these communications were sent during a public meeting where the individuals are meeting as a public body. And the location of the records, of course, does not matter. So we'll look a little bit more at this case when we get into public record. So how about subsidiary or sort of hybrid bodies, where you have a function, hybrid's my word here, but it's a governmental function and sort of a more private function or a public interest function. So public-private partnerships, such as Economic Development Corporation, things like that.
Can I ask a question on that?
Yeah.
Are those subject to it?
Well, so I'm asking you guys. So first of all, subsidiary bodies, the subcommittees and committees, those are explicitly included. I think we can dismiss with that.
Okay.
Where you have a formal part of the structure. Miriam?
So subsidiary, for those of you who don't know.
Oh, yes.
If you look it up, because the courts are going to look up the dictionary definitions of the words that the General Assembly uses, has a meaning of that it's under the control
Yes.
of the overbody.
Yeah.
So the subsidiary is under the control.
Yeah. So I mean,
that's the key term.
really, if you're talking something that's in that structure and created by, you're really going to get into that very clearly. But these public-private partnerships, a lot of times, an economic development corporation, what it is it's a nonprofit. It takes over some sort of traditional government roles in terms of promoting the state or the locality and business development in the area. What do you think? Are those subject to Freedom of Information Act?
Only if they share their documents with the government body.
Only if-
the government body.
Well,
has
yeah,
those
definitely if they share them with the government body. The government body, and that's something important to remember. Sometimes you have documents that could be under multiple, control of multiple entities. Absent that, does anyone think they would be subject to Freedom of Information Act?
There are relatively recent cases
There
with
was.
College DuPage where with the foundation.
There that's a good case, and I don't have that in here. Yeah, that's
know the
actually a great
details of
one.
that.
And you know what? I'll get into that. It's a little bit later in these other cases, so I'll talk about it a little bit. Well, the Economic Development Corporation, the Illinois one, is not subject to this. It's a nonprofit organization. It takes over a lot of the duties of the Illinois Commerce Department, and it has mixed funds. It originally was supposed to be funded privately, but it might end up getting some tax dollars. We don't know yet, I think, if that's going to affect anything. But as of right now, they have voluntary transparency. They say that they are going to have their meetings open. They say that they are going to comply with something akin to FOIA. What do you guys think about that? That's voluntary. Is that enough?
How sincere are they about
how
the
sincere are they?
balances?
Not to knock, the folks. I don't know the folks over at the EDC in Illinois, and they might comply with this. And I've never actually heard a complaint that they don't. But you are kind of relying on individuals, and it could change at their whim if it's voluntary.
And even if they're 90% publicly funded, they're not required, right? Under FOIA?
According, to Illinois' FOIA.
I think they're funded. They look at more than that. We'll get that in the next slide. So if a lot of their funding is public, and it comes directly from taxpayers, it's not through like grants or something like that. Those are some of the facts they're going to look at.
But in Illinois, it's very strict. They want to see if that body is under the control of the other body. Yeah. And with economic development corporations, the public bodies aren't in control of what's happening at the nonprofits. And so the case law has very clearly said, sorry,
that's definitely
you're
the
out
case.
of luck.
Yeah, if they're not under control at all, that's definitely the case. And I mean, that gets into some questions about use of public funds and how comfortable you are with it.
And in some states, like in Oklahoma, I believe, the FOIA is written such that any entity that receives a substantial amount of their funding, and they might have like a percentage in there, like 50% or more, or some other percentage from public funding, then they are subject. Illinois has nothing
No,
like
we don't.
that.
Yeah. So there's one other case I want to talk about before we go to the College DuPage one. This is IHSA, the Illinois High School Association, which governs sports in Illinois high schools. The way this is organized is that it is also a private organization, but think just about every public school in the state, I don't know if there are any exceptions, belong to this organization, and it governs all their sports, all the rules that they comply with, their championships, everything like that. What do you think? Subject to FOIA?
I don't think it is. Is it?
It's not. It's not. What the court really focused on here was that this was a function that the government might not otherwise take out. It wasn't sort of a mandatory function of government. It's not something that the state has just handed over government function and control of. What I know the proponents of the plaintiffs in this, what they really were happy about, despite losing the case, was that the court focused a little bit on that function question. I don't think we've gotten to a point yet where they're looking at government function as much as we like. I think with the EDCs we see that they've taken over a lot of the Commerce Department's functions. But the court gave some fairly favorable language in that direction, despite the unanimous decision against them. The College of DuPage case is really interesting because that was the foundation of the College of DuPage, controlled some documents, and this FOIA request was to the College of DuPage, but hit documents under the foundation's control.
They were requesting the federal subpoena, and the case said that because the foundation said we're a nonprofit and we don't have to turn over the subpoena to the college for the college to give to the requester. And the court said, by the facts of how the foundation operates, it's completely under the control of the college. They do all the fundraising for the college.
All the fundraising for the college.
And the college depends on that foundation, and they're so closely intertwined that there was no question that that they had to turn over the documents.
And that's really the foundation's only role too, is to raise money for this college, which is a public body. It's a community college. So the court there found that the foundation was subject to it. So it is a little bit in that gray area, but do you see the difference between that, the EDC, and that, where you have this foundation that was actually established by the college, the EDC that was technically incorporated separate of government, though I think it was Governor Rauner who actually incorporated it technically.
He was involved.
He was involved. But you have the function is just, it's very much within the purview of the college. It's taking over this role. So maybe with the IHSA case and that, they are getting a little bit more towards what role does this play. And we'll see if that trend continues.
Was the determining factor the structure of the organizational structure or the functions of what they did?
They talk at length about how the foundation, basically the relationship between the college and the foundation wouldn't exist but for the college, and the college, everything that the college, all the money that the college got was from the foundation. They were so closely intertwined.
Yeah, they really couldn't separate the two.
I don't think that
No, I think that's a good description of it. Yeah, they were so intertwined they couldn't separate the two. So.
So would that also apply to the foundation for a public library, for example?
Most likely it would, but they are going to have to look at the individual facts, and that's why we do see some litigation over this type of thing.
Very fact-specific, fact-intensive inquiries.
So some factors to look for, through the case law. Is the body incorporated separately from the government entity? If it's not, you're going to be probably under the control of FOIA. Is the body part of the formal structure of the government entity? In other words, what amount of control, if any, does the government have over the body? If the government's controlling the body, again, you're probably under FOIA, and maybe some gray area there as well. And then what role or function does the body carry out, and is it a governmental function? Again, this one they haven't put as much weight on, but maybe we're seeing a shift towards that. And I think our argument at CAC is certainly that should be a consideration. Sorry, folks, just a fire truck going by. If a body is not subject to FOIA, what you want to do is you want to look for public bodies that might have that information. So the Illinois Economic Development Corporation does work with the Commerce Department a lot. The Commerce Department is still a government entity here. It just has kind of been neutered, doesn't have much of a function, but it still gets documents from the Economic Development Corporation, and you can FOIA for those if they're in the control of the Commerce Department or any other entity, public body that is. So what is a public record? This is that second piece. We talked about public body. Here's public record. All records, reports, forms, writings, letters, memoranda, books, papers, maps, photographs, microfilms, cards, tapes, recordings, electronic data, processing records, electronic communications, recorded information, and all other documentary materials pertaining to the transaction of public business, regardless of physical form or characteristics, having been prepared by or for, or having been or being used by, received by, in the possession of, or under the control of any public body. Thoughts on that one? Broad. Yes.
Okay.
Very broad, right? Actually, in the preamble, there's some language about technology improving, and they even sweep up things that might come up in the future. They're very careful to show that they really mean anything regardless of format. They've named them, they've listed them out here, and they've put in some really inclusive language, right?
Well, and it's inbound as well as stuff they've created.
Yes,
So if
yes,
it's in their
yes.
possession.
So if it's received by, exactly. It doesn't have to be created by them. It has to be held by them. And, if it is held by them, it might be subject to the Local Records Act. They might, even if someone sends them an email, they might not be able to get rid of it right away. So that's important, too. They can't just dispose of any record at will. Any other thoughts on that provision as we begin to dig into it? Or that definition, rather. Christian.
They have to be pertaining to the transaction of public business.
Very important, right? So, back to Champaign v. Madigan. So you're right on track here. So you have these emails and texts between aldermen, between multiple aldermen. Those are subject to FOIA, right? What if those come from to or from members of the public?
Is it pertaining to the transaction? I mean, is it pertaining to the topic of discussion?
Well, that's one of the things they're going to look at. If they're at the meeting, really the question is going to be, is it their function as a member of that public body or individually? So now we're getting back towards them being individual legislators, right?
This is what I was getting at with my question earlier, and I guess
Yeah.
I was wrongly assuming, that all public business had to be done through the public email account, and all private.
No.
You cannot use your public account for private business.
It's a really good policy to have that you can only do it through a government account. I think that that would have saved the U.S. State Department a big headache.
Yeah. Some public bodies are adopting rules that if an employee or an elected official receives any government-related business on their personal account, that they should forward it to their work account.
Yeah, I mean, I can tell you, I interned with a federal agency, and we were supposed to do that at the time. It didn't always happen. I mean, the interns, it didn't matter quite as much, but even with the employees, it didn't always happen. With in Congress, I was a fellow for a congressman. Same story. They're supposed to keep work on work emails. Doesn't always happen. Especially when you got a phone, you don't know which account things are going to and coming from. There are mix-ups. So it's a good policy to have, and it's a good policy to enforce. I think most public bodies at this point do it. They've seen the problems with not doing it. But especially as you get down to the local level, some still don't, and you see a lot of violations of it. It's also a good individual policy to have. I think Mayor Emanuel is realizing what a headache it is if you don't do that. They dug through his personal email because there were public business-related emails in there. Any other thoughts on that? All right. So 2 elements to a public record here. So does the record pertain to public business? You guys nailed that. And then the second part. Was the document prepared by or for, used by, received by, in possession of, or under the control of any public body? So now let's think about that in the context of an email or text from a member of the public to an alderman. What do you think? Miriam?
It says received by. Oh, but an alderman.
But an alderman, a legislator, right?
But is it used by them? Is it something that I...
Well, is it used by them as the public body or as an individual legislator?
Right.
If I'm using it to make a decision that's under discussion among all the public body, if I'm using that information in that comment and saying...
I'd say if you rely on it heavily enough, or if you... If you cite it, maybe. I'd say if you're talking about it, certainly if you forward it to another member.
Okay.
I mean, that in terms of going towards an actual decision, you forward it to another member, and you both are making decisions. I think you're getting a lot closer to that being used by the public body. But it's a tough question. I think maybe an easier context to look at it in is the General Assembly. Those individuals in the General Assembly are not subject to FOIA. The federal FOIA specifically exempts Congress. The reason being, essentially, for their strategy, for their everyday communications, they need that leeway, or so they feel. I agree with them on this one. It's a tough thing with transparency, but having worked in a legislative office, if they didn't have that, they just wouldn't talk. It would be like they'd talk, they just wouldn't record anything. Yeah, exactly. So, I think it's easier to think about in that context. And when you think about the aldermen as legislators like that, when they're talking to constituents or internally within their office, it amazes me in Chicago that the aldermen have like full offices with full-time staff and everything. But it's really a question of, are they doing that in their legislator role or as the public body? Does that make sense? All right. What types of record are available? Each public body must make available a reasonably current list of all types or categories of records under its control. I caution that this does not have to be that specific. It's a fairly broad thing, but they are supposed to keep this. You're able to ask for that list so it can give you an idea of what they hold. When we get into the next thing, which is going to be submitting a FOIA request, and there's some good tips on that, I'll say that you're going to want to think about it beyond those categories.
Oh, I wanted to say something about your last point.
Yeah.
That I think is really important. The public bodies don't have to take these exceptions. It's always their prerogative
That's great,
to
yes.
give up the information.
Yeah.
So if you were to ask for emails for an alderman,
Yes.
they may give them up to you anyway.
Yeah.
So it doesn't hurt to ask. But they may take an exception that applies.
Yeah, case in point, I recently, in Elmhurst, we've been having a lot of complaints about O'Hare noise. They're doing a runway rotation. And an alderman here has been going to the regional meetings. There's some sort of committees and ad hoc committees that are making decisions about the runway rotation. And he was representing Elmhurst at these meetings. He submitted some recommendations that he had made that weren't voted on or anything. And we had some concerns over whether he was actually acting as an alderman or in place of the public body without a vote or anything. So I sent a FOIA request for all communications related to that, anything he'd sent in relation to that. In my opinion, he was acting towards that function of public body too, since he was representing them at the meeting. But Elmhurst didn't fight me on it. They got me the communications, and I generally find that that's the case here. But it did involve communications from an individual alderman to another public body, mind you. So I probably could have gotten it from that public body. But Elmhurst probably could have tried to fight me on that in terms of being an individual alderman, but they chose not to. They chose to give me those documents. So that's a great point.
Sorry.
No, that's excellent. So another thing with the types of records available, it's important to know the Local Records Act controls record retention. We are actually going to have an updated citizen guide on the Local Records Act on Monday, so check your email for that. Destruction of most public body records must be approved by Local Records Commission pursuant to reporting and scheduling by the public body. So there are pretty strict bounds for destroying public records. There are some very narrow types of documents that might not be a public record under the Local Record Act, but I have trouble thinking about what you would be trying to FOIA for that wouldn't be subject to the Local Records Act or another statute that would supersede that and cover document retention. Any questions on that before we get into sort of the nuts and bolts, how to submit a good FOIA request? All right.
So things if someone has written to a handwritten or whatever kind of a piece of postal mail or hard copy to a member of a board, and they share it with anyone else on the board, they should be keeping it. And then around an issue that they're discussing. You know what I mean? Or
yeah, that's tough. I mean, I think it would it would probably be a factual analysis, depending on what the document was, what they were, whether it was going towards the business of the public body.
Yeah.
So it's kind of factually
Yeah,
intensive
like
there.
it is.
Might depend, if you're talking about the General Assembly and it's just two legislators, no way, they're not going to have to share that. The General Assembly actually has a list on their site, good list of the types of documents that are available. Most of it's already public record for the General Assembly. You're talking about committee minutes and all the documents submitted to them and all these different things. The only things related to legislators' offices that are really going to be available under there are like their use of public funds, because that's not their role. That's really from the public body.
Right.
So I think in terms of communications to legislators, you kind of got to check those boxes of it being this public business and it being in their role as the public body. So you're probably going to look to things like, is it a decisional matter, and is it going broadly to the public body? Certainly if it's during a meeting. They're meeting as a public body.
Well, and the question gets really complicated, because if we're talking about elected officials forwarding information to other elected officials, now you're bringing in elements of the Open Meetings Act, and is there a quorum or a majority of a quorum implicated, and so
Yeah.
I could really throw a wrench in there and ask what happens if they step out of the chamber, but we're not gonna go there.
As long as their mic's live and that's fine.
So submitting a successful FOIA request. So FOIA requests must be in writing. That's step one. Public bodies may accept oral requests. A lot of them will if you just walk into their offices and say, hey, this is what I want. They will comply, but they don't have to. The Act requires that it be in writing. You don't have to use a provided form. A lot of public bodies will give you a form for FOIA requests. You don't have to do that. It can be any written instrument. Email, slip of paper, I don't know, anything you can think of that's in written form, including electronically. As long as they provide an email address. I suppose if you're sending it into the ether, it's smokes. I was thinking about smoke signals. I guess they probably more towards the oral request there. So consider what information you desire and what public body will have that information. So we've talked about this a little bit in terms of the types of records and different control and everything. You need to think about this in the context of, is this a record that they're going to have? They might have information you want, just through their general knowledge, or it might be scattered throughout a number of documents, but they don't have to collect that together. It has to be in a record. I think a good example of this, we've been trying to figure out website requirements under the Open Meetings Act, and it says that all public bodies with a website maintained by the full-time staff of a public body is subject to the website requirements. Well, what's that mean exactly? Maintained by the full-time staff. If they assign it to a part-time intern, does that take it out of their control? So we've been looking, do they have this specifically assigned to full-time staff, or do they have full-time staff that might handle this? So we had to do a pretty broad set of requests, asking for a list of full-time employees, to see if they have that. We know if they have a website or not. We looked for some job descriptions. We looked for whether certain employees were full-time or part-time. So it's been kind of a struggle to check those boxes and figure out where this information might be. And it's very different depending on which public body we're submitting to. And that's a common problem to run into. So you really got to think about what documents they have. That's that basic question. Also, use language that is both broad enough to capture the information you require, but also specific enough that you aren't going to hit provisions we'll get to in a minute about unduly burdensome or voluminous requests. Or that you're just going to get, bankers' boxes full of documents dumped on you that you're going to have to dig through. It's not fun to dig through things like that. So other tips here. Request a fee waiver or reduction. They can charge for FOIA requests for hard copies. Again, you can spec them for free. Your first 50 pages of black and white print are free. Yay. After that, they can charge up to 15 cents per page. That can add up really quickly. 100 pages comes out to, what, $15? Did I do my math? Yeah. So you get 500 pages, suddenly you got a $75 FOIA request. That's expensive. They can charge for actual cost of color copies or electronic records. So if they're handing you a flash drive or a CD, they can charge you for that.
The
They
cost
can-
of the
the
flash
cost of
drive
that.
or the
They cannot
CD.
charge you for the cost of searching, so the hours searched and everything. And this is another thing we run into. There was this in Wheeling. They were fighting a resident on FOIA requests, and they claimed that the village manager had spent almost 300 hours over the course of 9 months responding to her FOIA requests. 7.5 weeks over 9 months that they thought that they claimed the village manager was. Now, I don't believe that. if your village manager's spending essentially a day every week on one person's FOIA request, you're doing something wrong. But they also can't charge for that. So they were claiming it was driving all their costs up, and this is one of the attacks that we see on FOIA all the time. And it's a little bit of a battle that we have. And clearly the General Assembly is on the right side of this, saying that public bodies, it's part and parcel of being a public body.
Yeah. So you know when you first submit the FOIA request, and then so in writing, do you have to specify like how many pages you want, or do you just?
So that's another good point, and we'll get into some sample language. You can limit, besides requesting a fee waiver reduction, you can limit. I have that on the slide. How much you want to spend. So you can say, if this is going to cost more than $10, let me know, and I'll decide if I want to do it.
Can a government body be selective as far as charging? In other words, could they not charge person A but charge person B?
We've talked about that, and they can. I think you would probably have to show a discriminatory intent for that to. No, I take that back. If they were discriminating on a protected basis, like race or gender or something, you could probably hit them for that, a civil rights violation. But that's going to be outside FOIA. You're talking. Federal constitutional violations, but yeah, they can, and that's some problem that you can run into with that. Even if you request a fee waiver as a public interest organization, they don't have to give it to you. When was the last time we were charged for a FOIA? Yeah, I mean,
we have been charged for FOIA.
Yeah, it's been, but
we always limit it to like $5 or
yeah,
less.
and they usually
Yeah.
public bodies. I mean, it's honestly like. Most of the time, it's probably not even worth their time to add up the cost. It might $75 for 500 pages might be a lot for you. But first of all, they're going to do it electronically most of the time now. Second of all, the time for them to calculate, they're just not going to do it for the most part. A lot of public bodies just don't charge for FOIA requests. So some sample language here. I'm not going to read through this, but the folks in the room can see it on the screen. This is also taken. It's an excerpt from our Citizen Guide to the Freedom of Information Act. So I'm just going to go through a few of the important parts. You should state that it's a FOIA request. You should really get into describing those documents how I talked about. So you want to be broad enough to get your information, but specific enough that you're really getting what you want. You can see there's some sample language. You don't have to put this in about if a portion of it's responsive. If they're redacting information, or if I take that back, if there is information, if there's a document that has information in it that's subject to an exemption, they should be redacting that information if possible. You don't have to tell them that, but it's helpful too. It's a reminder, and it's letting them know that you're not going to let it go if they reject the whole document, where they could just redact a name or something. So good information to put in there. You can see in there the language about fees, as well as the request for a fee waiver. The fee waiver, you're requesting it because you're getting the document in the public interest, if you are. So if you're getting it in the public interest and you're going to distribute it in the public interest, you are allowed to do the fee waiver. So that's just the sample language. So timeline for FOIA requests. A public body has 5 business days from receipt of the request to respond. Now, 5 business days is a little bit, really what they mean is 5 working days. If the office is closed, if they're a part-time office and aren't open for a day, I don't think the courts or the Public Access Council are going to hold that against them. They often talk about working days, so it's clear that over holidays you might have some longer timelines for this. They may extend by up to 5 business days if they notify the requester in writing, and that has to include how much additional time that additional time is necessary, how much time that will be, so when they expect to get it back to you, and the specific statutory reason for the delay. They're limited on the reasons they can delay. They can't just do it as a matter of right. And in effect, though, they can hit these pretty easily. Yes, Christian?
This is an additional 5 business days to give them the documents, or to have a decision on whether or not.
Both.
Okay.
Both. Yeah. If they're gonna reject it, they can extend by 5 days too. They just within 10 days they have to have that full response. Otherwise, if they blow the timeline, then it's considered a denial, and you get into review and everything. And the other thing if they blow the timeline, they can't charge you for the documents if they do have to get them to you. So that's an important thing to remember. If you get past that 10 days and it's a really burdensome request, but not unduly burdensome. Well, I guess they can't claim unduly burdensome past 10 days.
Fail to respond,
if they fail to respond,
they can't take the unduly burdensome
or voluminous request. Yeah, so no matter how big so if you request every record they've ever possessed and they fail to respond to you, presumably they'd have to give them to you. I think that the courts would try to probably provide them some leeway there, but they presumably have to give you all those. So valid reasons that they can take the extension. The record's in a different location, requires compilation of substantial number of records. An extensive search is required. Compilation of responsive records in 5 days is unduly burdensome, but it doesn't trigger the unduly burdensome provision, which we'll get into. Or consultation is required. That might be with an attorney, with another department within the public body, or with another public body, different government before production. So those are those reasons. You can see it's pretty broad. As long as they name one of those, they're probably going to be able to do it. If you're asking for emails of aldermen or something, it's usually takes some time, communication back and forth to track those down, so they'll usually take the extension. Okay. When can they deny and take exemptions? We have a list here. We're going to go through most of these. Specified statutory exemptions. So the statute has very specific reasons in terms of the substance of the request and of the records that they may be able to deny it. We'll go through some of the more common ones, but this is a long list of exemptions. It also includes exemptions from other state and federal laws, so we obviously can't go through all of them, but that's something to watch out for. Information on public body website. We're not going to talk about that beyond if you request something that's on the website, they can point to it. It does have to be that actual document. It can't be an imperfect copy or something along those lines. It's got to be that document, but if it's on their website, they can just point you to it. Unduly burdensome requests. We'll get into that. If your request is unduly burdensome, they can restrict your request. Voluminous requests, same story. If it's a really big request for a full category, a broad category of documents. Recurrent requesters. If you request too often from the same public body, you might be a recurrent requester, and they can slow their response to you. And then commercial requests. We're not going to get into commercial requests. We don't deal with them too much because we're trying to help typically members of the public and citizens. We do get some questions about that and some commercial related requests, but we're not going to get into that today. So first of all, statutory exemptions. We talked about this a little bit. The case that's controlling here and that the Public Access Council likes to cite to, as well as a lot of later cases, is Lieber versus the Board of Trustees of Southern Illinois University, and it says the exemptions from disclosure are to be narrowly construed. You can also see that from the statute. They talk about where the burden lies, clear and convincing evidence the public body has to show that they should be able to take this exemption. So the burden is on the public body. When a public body claims an exemption, one of the statutory exemptions, they need to do it in writing. It needs to be within the time limit specified by the statute, so that 5 days or 10 days if they've taken the extension. They need to notify the requester of the public official responsible for the decision. They need to include the specific exemption that they're taking and the reasoning for that exemption. So they can't just say, personal information, we're not doing this. They need to say, give a little bit more about the nature of that record, why they can't redact that information if it's something like a personal record, or if it's maybe an investigatory record, why it's going to interfere with their investigation. Obviously, they don't have to sort of violate those provisions by giving you it, but they need to give some description of why they are taking that exemption.
But as a matter of course, you'll never see the clear and convincing evidence in your denial letter.
Yeah, you really
I've
won't.
never seen a public body provide that. They just take the exemption. And then you have to do the request for review process to force them to give up the clear and convincing evidence.
Right. Yeah, and I'd say, usually what you want to think about is if they deny and if they give, kind of a half reason, is there some substance to that? Maybe do you want to try a different way again the information, or is this something where they aren't going to have clear and convincing and you want to go through with it? They also need to notify the requester the right to appeal both the public access counselor, and that's within 60 days, or to a court. So some common exemptions. I'm not necessarily even going to go through all the ones we have on the screen because time-wise we're getting pretty close. But private information, such as personal contact information, social security number, possibly a home address. I suppose an elected official, their address might need to be public record for elections, but private individuals, they can't give that away, or medical records, anything like that. Personal information. So this is a little different. Personal information which is highly personable or objectionable to a reasonable person and in which the subject's right to privacy outweighs any legitimate public interest in obtaining the information, but this cannot be claimed if the information bears on the public duties of public employees and officials. So this might have more to do with if they have record of some personal conduct or personal preferences, anything along that line. So it's not that private information, but it's information of a personal nature that if they disclosed it, a reasonable person would find it highly objectionable.
And oftentimes that is taken when it's a citizen who is corresponding with public officials, and the government body wants to protect that citizen's right to privacy because in this balancing test of whether that privacy outweighs legitimate public interest, they find that it does.
Yeah. And, often this is a case where they can redact a name. An example I think they tried to take that District 205 when they restricted the LGBT ally group from the morning announcements. There were parents corresponding with some of the public officials, and I think they tried to take that exemption. And the question was whether they could just redact a name or whether there was other information that would kind of alert the public to who that person was. So that's kind of a good example.
Yeah, it's a very fact-intensive, again, really fact-intensive question.
Yeah.
Does that have to be applied consistently within either the request or, by a government, by the body?
Yeah, I mean that's.
Or you don't know because you're not.
It does
it's
not.
fact-intensive.
Short answer, no.
No.
Because the public, because they're in control of whether they take exceptions or not.
So
right.
Unless it's information that's otherwise, they're otherwise restricted from giving away. So a lot of that's going to be more towards the private information, things like the what's the student records? I'm blanking out on the name.
FERPA or
FERPA, yeah. Or medical records or things like that. But yeah, depending on the personal information, there might be that statutory protections as well. The public officials part's interesting, right? One of the ones that jumps out at me is maybe conduct by an official during public hours or something could bear on their ability to perform that function.
But oftentimes we'll see like public officials who get like DUIs or
DUI.
Something else that happens like in their personal life, so to speak. Yeah. But it does bear on their public duties.
Right. Well, and I'd say if it's an arrest record, that's gonna they're going to be able to do that anyway. But then things related to that, maybe information within it that's really embarrassing about where they were or some deviant behavior associated with it or something along those lines. In some ways, I think that's unfair if you're talking about just your lowly employee of a giant public body. So I think there's going to be a question there, though, of again if it bears on public duty. So if it's during work time, yeah, it's going to.
Right, like if you're taking off work to go to the bar,
Yeah, exactly.
even
exactly.
though you're drinking, that's not public business. It's during work time.
Yeah. All right. Law enforcement and other investigative records have a narrow exemption. This one is fairly complicated. I would suggest you look at our guide on this and definitely consult if you're having issues with this one. There are a lot of moving pieces, but generally, investigative records in the possession of any public body created during administrative enforcement proceedings or any law enforcement or correctional agency for law enforcement purposes can be withheld if, so there's this other part of this, if they interfere with pending or actually reasonably contemplated law enforcement proceedings that is the I'm missing a word there, that is recipient of the request. So, in other words, if this document is going to if release of this is going to give away a piece of that investigation, and they aren't going to be able to investigate to the extent that they need to, that would be withheld. But if the investigation's over, it's not going to apply. Interfere with active administrative enforcement proceedings conducted by the public body that is recipient of the request. Similar question there in terms of enforcement versus investigation and where they are in the process.
And may I point one thing out? Both of those say that is the recipient of the request. So if you've got two law enforcement agencies, and one law enforcement agency has records, and you're asking them for the records, and they're not investigating, and they say, "But look, this other law enforcement agency is investigating." Well, guess what? This other law enforcement agency is not the recipient of the request. It's the first one. There's been some pushback on that too. They've tried to amend the law, and I think they might have some success soon on that. We'll see. It's a tough call because you don't want to, and it makes sense. I think from a public policy perspective, you don't want to interfere with law enforcement investigations, but at the same time, it's what cuts against that is the abuse of this when they aren't releasing body cam footage and things like that. It kind of cuts down on the leeway that I think the public wants to give those officials. So we're continuing that if they create a substantial likelihood that a person will be deprived of a fair trial or an impartial hearing. So, if the court proceedings are still going and this would just get too much information out there for them to actually receive a fair trial. Or unavoidably disclose the identity of the confidential source or information that could only be furnished by the confidential source or persons who file complaints with or provide information to administrative, investigative, law enforcement, or penal agencies. So they do not want to give away those witnesses and confidential informants, and they can take that exemption under this. There are some issues with this. Cold cases are one of them. We've seen some public bodies try to take this exemption with a cold case. Well, that could go on indefinitely, right? There's kind of a problem with that. I think it was up in Lake Bluff that someone was trying to uncover some old murders or something, and they took this sometimes
exemption.
When I see in the news like an investigation's been reopened, I think, who FOIA documents about that investigation?
Exactly.
That they reopened it.
Yeah. And I mean, that's sort of near and dear to my heart. One of my high school teachers and a couple of classmates got the Mississippi burning criminals imprisoned, convicted and imprisoned, 40 years later. And it's a cold case. That's people digging in and getting old documents and doing the legwork to interview people who maybe change their mind on things. More common exemptions: preliminary drafts, memos, etc. As long as they have not been publicly cited by head of a public body for a decision. So that's the important part here.
During a meeting.
It can be it can be outside of a meeting if it's the head of the public body that cites it. So this is really important. And someone asked about this before. Did you ask? Yes. Okay. Yeah. So this is those emails and things, memos, where they're getting towards a decision. They can take an exemption and say that those are not subject to FOIA, or that they're an exemption from FOIA, unless the head of the public body cites to that as a reason for the decision. So, say Elmhurst is changing their parking restrictions and they're going to charge $10 an hour, and they have all these memos about the costs and what it's going to do with traffic and everything. If they just make the decision and don't cite that, if Mayor Morley doesn't cite that publicly, you'll never get those memos. If he says, well, we have these memos and studies and we're making this decision, then you have a right to those. Trade secrets, bid information, when disclosure would frustrate the procurement process or provide unfair advantage to a bidder. I think those are pretty clear, just private economic decisions, essentially. Various educational records, we're not going to go through all those, but student records are generally exempt from disclosure and actually required to be kept private. Another one to think about is, I think it's on the next page here, adjudication of employee grievances and disciplinary matters, except that the final outcome of any adjudication is not exempt. So if employees are in trouble for something and they're going through a process, only that final outcome, if there is one, is subject to disclosure. Records specifically exempted by another federal or state law. We'll get into an example of that in a second. And then attorney-client privileged records. Similar to if you or I hires an attorney and has privileged records, well, they're privileged. They can be exempt from FOIA. Again,
one thing to note there is that doesn't mean all records between an
right,
attorney and client.
right.
It's really specific what kind of communication it is. So it's not
That's
a
a good
blanket.
point.
Attorney-client privilege is not this blanket thing that people can take. It
Yeah,
has
that's
to
a
be
really good
specific
point.
to work product and something else, strategy.
Yeah. So this specific statute one, we had an interesting example recently in Illinois. A gentleman requested an accident report from the Illinois Commerce Commission related to a railroad accident. A train hit a vehicle. And the commission cited a federal law that states that reports, surveys, schedules, lists, or data compiled or collected for the purpose of identifying, evaluating, or planning the safety enhancement of potential accident sites, hazardous roadway conditions, or railway highway crossings shall not be subject to discovery or admitted into evidence in a federal or state court proceeding or considered for other purposes in any action for damages arising from any occurrence at a location mentioned or addressed in such reports, surveys, schedules, lists, or data. What do you think? Can they take that exemption for the railroad accident report in this case? Any thoughts?
It's really broad.
It's broad.
It's not broad.
Is it broad? Yeah.
It's narrow because it says
Safety
that basically it
enhancement?
can't be.
Well,
it
safety
can't-
enhanced. So it's about the purpose, but there's something even more narrow
It has
here.
to do with it's not subject to discovery or admitted into evidence in a court proceeding.
Right.
Oh, so
That's
it's
really
only
narrow.
tied to court
Right.
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 So you can have the document, but you just can't admit it into evidence into a court proceeding.
Got it.
So he submitted a request for review with the Public Access Counselor, and we'll talk a little bit about how to do that. And he got a determination letter saying that the Illinois Commerce Department needs to release this information. What this is trying to keep people from getting these records when they're suing a government agency. It's about public policy of getting the information out there and not having those bodies be afraid of a lawsuit. So it's honestly, it kind of cuts against their argument. I mean, FOIA is a great reason to, kind of hand in hand with that. It's a good reason for them to have that exemption from court proceedings. So let's get into a few of the, not these statutory substantive exemptions, but things that have to do with your request. First one, unduly burdensome request. A request calling for all records falling within a category shall be complied with unless compliance with the request would be unduly burdensome for the complying public body, and there is no way to narrow the request, and the burden on the public body outweighs the public interest in the information. A few things here. We talk about this categorical nature, right? Within all records falling within a category. So you got to have a pretty broad request to even trigger this provision. When you do have this situation, a public body must reach out to a requester to offer them the chance to amend or reduce the request. So if Elmhurst gets back to me and says, well, that's an unduly burdensome request when you ask for all of the Elmhurst arrest records for the last 400 years, I can narrow the range, I can narrow the type of arrest, anything like that. Denial must be in writing, and it must specify the reasons and extent to which it will unduly burden the resources of the public body. And repeated identical requests may also be unduly burdensome. Any initial questions with this?
Is that the only thing that becomes unduly burdensome, meaning all records within a category? Or is it just the nature of, it's going to take you're asking for 6,000 documents, that's just too many.
Well, I mean,
Is it judgmental?
I think what you might get to there is if you're asking for specific documents, you're going to get into the recurrent requester provisions, so that can slow down their response. If you're asking for those 6,000 documents in any sort of categorical nature, they're probably going to be able to trigger this. If I ask, even if I narrow that request from Elmhurst from 400 years down to 4 years, it's still categorical. It's all records from those 4 years. Now, if I ask for specific records, if I ask for Joe Smith and John Smith and Jack Smith's arrest record from such and such date, that's a different story. Those are specific documents that aren't categorical.
And one important court case on this that gives us some guidance on what's unduly burdensome is Shahade v. Madigan. Mm-hmm. And the fellow Shahadigan asked Lisa Madigan for all the determination letters, for all the requests for reviews, for Open Meetings Act and FOIA disputes. And that's categorical, right?
Right.
And the court said, and it would be 9,000 pages. And what was unduly burdensome is that the Attorney General doesn't keep these documents all in like one big file. They're all separate PDF files. And the court said 9,000 documents of this nature, that's unduly burdensome.
And remember, it does have to be, in addition to being that categorical nature, it does have to be unduly burdensome. So, if the AG kept those in a box and had them right now, it's not going to be unduly burdensome. Now, if they have to go through and redact everything from that, that's another story, which they do, and that's part of that. The other thing to look at here is the balancing nature of this. Outweighs the public interest. So if it's something that's so important to public interest, it can outweigh that burden. I don't think we really have much case law on that, and I don't think it's anything that the public access counselor is going to want to take the fight to anytime soon. But it's a really interesting point here, especially when you consider some of the recent fights over these documents, like in the city of Chicago, where there has been a strong public interest in this, especially in police records. If they were looking for maybe things related to disciplinary actions against officers, and it would otherwise be unduly burdensome, maybe there's a public interest argument that outweighs the unduly burdensome nature. If you do have so we went through a repeated identical request as well, may be treated as unduly burdensome. So that's not that categorical nature, but if I keep asking for the same thing, they can just ignore me pretty much because I'm annoying them. All right, voluminous requests. Important note here. News, nonprofit, scientific, and academic entities are generally exempted from this. It has to be going towards sort of news or public interest. It can't just be that you're a public interest entity, but it's for a sort of narrow, self-serving purpose. It's got to be towards this news or public interest. But then you are not subject to the voluminous request provisions. So voluminous requests, what happens if you have a request is results are, it will result in delayed response and increased cost. They can charge you more under this, as well as delaying your request. A public body must give a requester 10 days to amend or withdraw a request if it's going to be voluminous. So they have to notify you in writing that your request is voluminous and that you have the right to make it not voluminous. If it remains voluminous after that, it's going to be treated as such, and they have to notify you within 5 days that they're going to treat it as a voluminous request. They have to tell you an estimate of what the costs are going to be, as well as an estimate of when they are going to get it to you. And they can extend the response period by 10 business days. Voluminous requests, so what's that mean, right? It includes more than 5 individual requests for more than 5 different categories of records, or a combination of individual requests that total requests for more than 5 different categories of records in a period of 20 business days. That's a little confusing, right? Really what they're looking at is, are you requesting more than 5 different categories of records? Now, what's a category of record? Maybe it's that document they have about the categories of records they have, but that I said they have to provide this sort of formative document. But there are plenty of things you can request that aren't going to be squarely covered in there. So that this is kind of an open-ended question of what's a category. But that is the general thing they're looking for, is 5 different categories of requests within 20 business days. Or if a single request requires a compilation of more than 500 letter or legal-sized pages of public records, unless a single requested record exists. Sorry, I take that back. Multiple requests that require more than 500 pages. So even if you have two and they're 251 and 250 pages, you've triggered it. Whereas if you have one that's more than 500 pages, they can't use the voluminous request provision. A single requested record may include, but is not limited to, one report, form, email, letter, memorandum, book, map, microfilm, tape, or recording. So that's kind of what we talked about with different types of records. But if you ask for multiple of any of those, if you ask for something containing multiple of those, you're probably going to trigger that. Does that make sense? It's not a very clean provision. I don't think we were very happy when it went into effect.
Yeah, generally the reason why the public bodies were pushing for this amendment is because there are some actors who submit FOIA requests that the public bodies claim are harassing. They're just harassing. Let's say someone who loses an election and then they're fighting, they're asking all these FOIA requests of the person who won. And so because of these bad apples that are so rare, they created this. Now, will this be used against someone who is legitimately trying to, in the public interest, get information and act civically engaged? It might be, unfortunately.
You can always incorporate and get around it. So, any other questions on voluminous requests before we go on? I know it's not it's really not a very clean provision, and it's, what is it, 2013 or 14 it went into effect? Or was it a little earlier?
So.
It's pretty recent, so there really hasn't been much. I don't think there have been any cases on it, and the PAC has maybe issued one or two.
Yeah, the PAC doesn't like this provision because it's so messy.
Yeah.
It has these weird provisions for charging up to $100 if the electronic record you have is so many megabytes or kilobytes or something like that. And the public the public access counselor says they don't want to be measuring how many kilobytes and megabytes these records are to determine. Right. I mean, it's just ridiculous.
Yeah. So, and the cost schedule, the additional cost schedule is also on our guide, so you can see that. I want to jump to recurrent requester. I know we're running pretty close on time. Again, news, nonprofit, scientific, and academic entities are generally exempted, again, for those same reasons. So a recurrent requester is someone who, in the last 12 months, has submitted 7 requests, in a 1-day period, 15 requests in a 30-day period, or 50 requests or more in a 365-day period. What is a request? A single request may ask for multiple records. So if I send one request for 5 different records, that's still only one request. It is not 5. So that's important to remember. So it's really that one email you send to them or letter you send to them, that's a request. So 7 in 1 day, you should probably try to get that into one or 2 emails. 15 requests in a 30-day period or 50 requests in a 365-day period. We do see people trigger this. This is, again, getting after the possibly people who are looking to harass a public body. It is one of these things they're trying to limit how much a public body has to, what responsibility they have under this. So that's why I push back a little bit more when a public body says, oh, this is costing us so much. They do have these provisions which help them out. All 3 of these last provisions help them out in terms of costs. Christian?
Yes, for the village of Wheeling.
Yeah.
In that scenario, was this
was she a recurrent requester?
Yes.
Towards the end, they said she was a recurrent requester, but she'd been pretty careful not to be.
Okay.
I think they were including when there were requests for review and things along those lines as well. That the village, again, I don't know why the village manager was necessarily working directly on that, but I don't believe it was. I think it was towards the end that they said she was a recurrent requester. And I would say if you're submitting a lot of FOIA requests, keep track of them. Try not to become a recurrent requester because you're going to see on the next page what happens. A public body must respond within 5 business days notifying a recurrent requester that he is being treated as a recurrent requester. That is going to delay the timeline for response. After that, they must respond again within 21 business days with an estimate of the response time and cost and the cost that they expect to incur, or if they're going to assert any exemptions. So they have 21 business days to respond if they're even going to take an exemption to a recurrent requester. That's a long time to wait for them to let you know that they're not going to give you anything. That estimated response time, it must be reasonable, but we don't have too much guidance on that. So if you're a recurrent requester, you're going to be waiting a long time to get information. So you don't want to become a recurrent requester. And remember, that's to one public body. So if you send 7 requests today to Elmhurst and 7 to Villa Park, 6 to Elmhurst and 6 to Villa Park, you're not a recurrent requester for today. All right, request for review. So if your FOIA request is denied, there are really 2 paths you can go down to overcome that. You have going to court, suing. We aren't going to talk too much about that, but generally the important thing to remember is you're supposed to be on an expedited basis there. They're supposed to give preference to FOIA suits over some others. You can also recover attorney's fees and other costs under that. But then you have the request for review, which is free. It's an administrative process. We help people out with this all the time. It's an enforcement process through the Attorney General's office. The public access counselor's an office within there that handles these. This process can take a long time. It can take a matter of months. If they're going to issue a binding opinion, they got to do it within 60 days with a possible 21-day extension. They only issue about 15 a year, maybe. So that's not too many. They get thousands of requests for review a year and do that. But you also might get a determination letter even if you don't get a binding decision. Public bodies aren't necessarily, they don't have to listen to those determination letters. But if they don't, it's something you're going to be able to take into court and say, here's the AG's opinion. It has a lot of persuasive weight. Certainly in terms of a public interest battle and just sort of bringing it to a meeting and saying, look, this public body is going to get sued and spend all this taxpayer money if they don't comply with this and they're supposed to. It has a lot of weight that way too. Request for review must be in writing. They must be signed by the requester and must include a summary of the facts supporting the allegation, and it must be within 60 days of the denial of the alleged violation. So if they deny your FOIA request and you don't think they have the right to do that, within 60 days you must appeal to the PAC. If the PAC believes further investigation is warranted, they will forward the request to the public body and ask for documents related to that. The public body has 7 working days to respond, and then you will also be given 7 days to respond to their response, so to rebut their arguments. We talked a little bit about binding opinions and non-binding determinations. Again, public bodies usually will follow. There is a trend for them not to necessarily follow and to have to go to court, but it is an advantage if you've gone through this and gotten an opinion from the public access counselor. So that is our last slide. I know we ran a few minutes over, but I want to give Susan a second to talk. I also want to thank Illinois Humanities. We are funded in part by a grant from them and from folks like you who support us throughout the year and make events like this possible. So Susan, thank you.
I'd just like to thank you all for coming. At the Citizen Advocacy Center, we really celebrate the work of activists like you in your community, and that's why we exist, to help you keep government more transparent and accountable, but it can't happen without your efforts. And our work can't happen without your financial support. So I'm just here to give the fundraising commercial and to ask you to consider making a fully tax-deductible donation to the Citizen Advocacy Center. There are a myriad of ways that you can do that. You can go online, you can send us a check. We have a dip jar. Is it over there on the table?
Yep, it's on the table right there.
Where you can make a credit card contribution as you're here today. So thank you again for coming. And
if you've given already, thank you so much.
Yes,
Thank you.
yes. We've already had your support. But please consider coming to more events. And if there's any way that we can be of help to you, that's why we're here. So
call us.
And our next event is January 20th about building an issue advocacy campaign. So we're going to take these last 3 discussions and pull it together, talk about some specific examples of campaign. Thank you all for coming. Thanks to folks. Thank you to the folks on Facebook who tuned in, and we hope to see everyone soon.